7 minutes.
Thank you. The spectre, if I could call it that, of Abbey Lara has hung over this House for quite some time now, and it predates my membership of this House. And what we have here tonight is an honest approach to dealing with the legalities surrounding that judgment that would once and for all put the issue to bed, so that the legislative functions that we have relative to the executive could be dealt with in a meaningful way. And I think it is about time, and I say this as somebody who is on his first mandate, that it is about time that this issue was dealt with in a substantive way. Could I just, Alas Ceann Comhairle, outline some of the principal features of the bill? And I think it is worth reading the principal features into the record, because I think they are so clear that it is very hard to fathom why they wouldn't be taken on board by the government at this stage. The purpose of the bill is to address a pressing need to restore the status of the Oireachtas vis-à-vis the executive. In particular, we need to address the view that the Supreme Court decision in the Abbey Lara case has put an end to any possibility of inquiry by an Oireachtas committee. We reject the view that short of constitutional change, there is now no lawful means of holding a parliamentary inquiry as a result of that decision. We do accept, however, that legislation is required to address the defects identified by the court in that case, hence this bill. Now, I stand before you, Alas Ceann Comhairle, as a member of the Economic Regulatory Affairs Committee. We have dealt with quite a number of bankers, in the last number of years, and in that time, we have had this spectre of Abbey Lara hanging over us, in that every time a witness comes before the committee, we had to be very careful about how we might question such a witness, and the issue of compellability was also something that loomed large over any proceedings if you check the records of that committee over the last number of years. If you fast forward to the announcement by the Minister for Finance that they would hold an inquiry in public, or in private, forgive me, it beggars belief that they would use a Supreme Court judgment or hide behind a Supreme Court judgment as an excuse for not holding such an inquiry in public. And that, to my mind, is an affront to any member of this House who puts their name on a ballot paper and who seeks to represent the people, because it disallows the possibility that people who may have been responsible for undermining our banking system, our very economic structures in this country, would be able to hide behind such a judgment as an attempt not to answer questions in a public fora or in what I would call the tribune of the people. And I think the people demand that this issue be dealt with in a meaningful way, and I think that this bill does so, and I would ask that the government would seriously consider taking it on board. I think it is right and proper, and particularly from the point of view of the banking crisis that we have witnessed, it is right and proper that ministers for finance, their officials, various actors within the banking stage should be subjected to rigorous questioning in the public interest and within the public domain, on the basis that the taxpayer has bailed out some of those very institutions, and those very institutions have received a guarantee under the auspices of this state. I think it is only right and proper that we would have such proceedings in public, and that any excuse that might be put forward then by ministers on the government side of the House that they are restricted in doing so by virtue of a Supreme Court decision. Well, this legislation will deal with that very issue, and no excuse could be found for not having such public inquiries. I just want to state that it is not right or proper that somebody who is a member of the Economic Regulatory Affairs Committee, for instance, which has a particular remit in respect of the banking sector, would have to glean whatever information they glean from the business pages of the Sunday papers. And it's very clear to me that when I read the Sunday Times, or if I read the Sunday Tribune on any given Sunday, that the amount of leaking that has come out in relation to issues surrounding Anglo-Irish Bank, for instance,
1 minute,
would tell you that the government is selectively talking to journalists, and that, to my mind, subverts the very role that a committee such as the Economic Regulatory Affairs Committee or any other committee of this House would have. And I would state that the government, if it takes a historical perspective, and I know that Minister Mansur would be conscious of this, that if it takes a historical perspective, that it must be seen to be doing right by the people, and the only way you can do right by the people is by conducting your affairs in a public fashion.
Deputy